This conference will now be recorded.
Good afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our January 21st, 2021 public meeting. Happy New Year. This meeting is being held via teleconference pursuant to Governor Cuomo's Executive Order 202.1 due to the coronavirus emergency. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of multi-dwelling buildings from commercial and manufacturing spaces to safe rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the Loft Law and the Loft Board rules. Before we get started, I would first like to welcome our newest board member, Mr. Christian Hilton. Christian Hilton joins the board today as the owner's representative. Christian has been an attorney practicing in New York for over 20 years with a focus on land use matters. He has worked extensively in the public and private sectors as counsel to the Land Use Committee at the New York City Council and is currently a partner at Philip Neiser LLP. So welcome, Christian. I don't know, Christian, did you want to say a few words to the public? You could, no? You could take yourself off.
Not necessary. Let's go straight in.
Okay, great. Thank you, Christian. Okay, we have in addition to today's agenda, item number 5 will be put on the topic of the professional certification and self-certification processes at the Department of Buildings. We had previously discussed the matter in November, and the board had discussed the possibility of passing a resolution at today's meeting. However, as this is Mr. Hilton's first board meeting, Mr. Delaney rightly pointed out that it would be kind of unfair to ask Mr. Hilton to vote on a resolution right away. So Mr. Delaney will provide an overview of the topic when we get to the item number 5, and we'll table the resolution for February's board meeting. We first turn to a vote of the minutes from the November 19th, 2020 public meeting. Are there any corrections or comments on the meeting? Ms. Lynn, did you want to make mention of one correction?
Oh, yes, thank you, Chairperson. On page 6, halfway down the page, there's one typo where it says the Chairperson is encouraging members to sign up. It says S-I-N-G instead of S-I-G-N, and that will be corrected before it's posted.
Okay. Great, thank you, Ms. Lynn. So I have a motion then to accept the minute. Board members, you remember you have to take yourself off mute to make that motion. Okay, and Mr. Hernandez and Mr. Barr is second the motion. Ms. Rivera, could you please poll the board members?
Mr. Roberts?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Hilton?
Yes.
Mr. Delaney?
Yes.
Ms. Rosen?
Yes.
Ms. Torres?
Yes.
Ms. Brajan?
Yes.
Chairperson Hilton?
Yes.
9 in favor.
Thank you, Ms. Rivera. So next item on the agenda is our acting executive director's report. Ms. Lynn.
Thank you, Chairperson. On December 30th, the governor issued Executive Order 202.87, which suspends the in-person meeting requirement of the Open Meetings Law to January 29, 2021, and that's why we're allowed to meet virtually today. In terms of revenue, the unofficial lawful revenue for December 2020 was $13,175. Enforcement, we issued 1 violation in December 2020. One violation was issued at 144 Spencer Street, Unit 610, Brooklyn, New York, for inadequate heat. In terms of litigation, we have one decision, and that's Fair Japaning Inc. versus Anna Bielobroda versus New York City Loft and New York City Loft Board. So the Appellate Division First Department issued a decision affirming the lower court's dismissal of this Article 78 petition, challenging Loft Board Order Number 4575, dated November 17, 2016. LBO 4575 denied owner's letter seeking reconsideration of LBO number 45110 as incomplete and untimely. Owner has submitted the application letter by fax, did not include required Loft Board forms, failed to timely pay the application fee, and failed to provide proof of service. The lower court had dismissed the Article 78 petition and owner appealed. The First Department now affirms the dismissal, finding that Loft Board's construction of this rule as requiring reconsideration applications be filed by mail or hand delivery is rational and entitled to deference. And that is my report.
That's all you have? Are there any questions for Ms. Lin?
I have one question. Do you have any update on the matter that we discussed in executive session back in November?
No, not yet.
Okay, thank you.
Ms. Lin, I have a question on the enforcement matter, the Spencer Street violation.
Yes.
Is there status on that? Like, did they correct the violation, cure it?
I don't have that information available right now. Let me check with our inspector, and I will report back to the board.
Thank you. All right. Are there any other questions for Ms. Lin? Okay. We now go to the vote on the cases. The first item on the appeal and reconsideration calendar. There's only one case on this calendar. That case is 475 Kent Owner LLC at 473 through 493 Kent Avenue in Brooklyn. That number is AD0104. And Mr. Argov will present this case.
Thank you. Good afternoon. Before I begin the presentation, I'd just like to apologize for and note a minor error in this proposed order. On the middle of page 2, you'll find a paragraph which begins on November 27, 2018, owner filed an amended narrative statement. At the bottom of that paragraph, there's an additional and unnecessary "the" before the words gas system. We will remove that "the" before gas system, so a revised version just reads the existing gas system. I apologize for any confusion for that error. Now onto the proposed order. This proposed order rejects the appeal filed by the owner of the building located at 473-493 Kent Avenue. The appeal challenged the administrative determination which denied owner's second request for an extension to its code compliance deadline, second extension application. Owner filed its first extension application in February 2017. In that application, owner requested that its code compliance deadlines be extended and requested its multiple dwelling law Article 7B compliance be extended to July 24, 2019. In April 2017, the 2017 determination was issued, which granted owner's first extension application. Owner's Article 7B compliance deadline was extended to July 24, 2019, as owner requested. In February 2018, the Kent Tenants Association, or KTA, a group of tenants within the building, requested additional time to file comments or alternate plans to owner's proposed legalization plans for the building. KTA's request was granted in an administrative determination, referred to as the 2018 determination, which gave owner and KTA 21 additional days to reach an agreement on the plans, and also provided owner with a 21-day extension to its permit deadline. In November 2018, owner filed revised plans with the Loft Board, which replaced the building's gas system, even though previous plans retained the existing system. In April 2019, KTA filed an alternate plan in response to owner's revised legalization plan. In June 2019, owner commenced litigation in New York State Supreme Court seeking an injunction, claiming that KTA was barred from filing an alternate plan due to a prior settlement agreement. Owner's request for an injunction was ultimately denied in Supreme Court in April 2020. On August 14, 2019, owner filed its second extension application after its July 24th Article 7B compliance deadline had already passed. On January 23, 2020, the administrative determination was issued, denying the second extension application due to its untimeliness, the fact that owner was previously granted an extension, and that owner failed to meet the statutory standards for an extension. In March 2020, owner filed its appeal. This proposed order rejects owner's claims that its application was timely. NDL Section 284 does not automatically provide an owner an 18-month extension to achieve Article 7B compliance. Rather, an owner is required to achieve Article 7B compliance within 18 months of obtaining a permit under the MDL. Owner also argues in its appeal that its Article 7B deadline should have been extended by 21 days when owner's permit deadline was extended by 21 days in the 2018 determination. The extension owner was granted for securing a permit applied to that deadline alone and not to other deadlines. The former executive director was therefore justified in denying the application based on its untimeliness. Additionally, owner's challenges to the deadline set by the 2017 determination and 2018 determination are untimely. Owner had the opportunity to appeal these determinations, but chose not to, and its time to do so has long since expired. Owner also cannot be granted an additional extension under 29 RCNY Section 201B3, since it already receives one. In its appeal, owner claims that 29 RCNY Section 201B1 and B3 allow for separate extensions of the code compliance deadlines, but offers no legal authority to support these unfounded assertions. Since 29 RCNY Section 201B3 clearly states a party is limited to one extension, owner's claim that it was entitled to an additional extension is baseless. This proposed order also denies owner's appeal since owner has failed to meet the statutory standards for receiving an extension. Owner contends that its compliance efforts were thwarted by circumstances beyond its control, such as a lack of access to units within the building, and the fact that KTA filed an alternate plan. Owner, however, fails to provide sufficient proof of impeded access. Furthermore, owner took steps that were entirely within its control by changing the building's legalization plans and commencing litigation. Therefore, this proposed order rejects owner's contentions that it was unable to meet its legalization deadlines due to circumstances beyond its control. Owner also failed to prove its good faith efforts to legalize the building. In the appeal, owner argues that the affidavit of its project manager is sufficient proof of good faith efforts under Loft Board rules. While an architect's statement is mentioned in Loft Board rules as a possible form of proof, a statement by an architect without corroborating proof does not in and of itself prove good faith efforts were made. An owner bears the burden of proof to demonstrate its good faith efforts to legalize the building. And in the instant case, owner did not provide sufficient proof of its good faith efforts, and therefore failed to demonstrate it was statutorily entitled to receive an extension of its Article 7B deadline. This proposed order finds the administrative determination properly denied owner's code compliance extension application due to its untimeliness, as a previous extension was already granted, and because owner failed to prove it was statutorily entitled to an extension. As such, this proposed order rejects owner's appeal.
Thank you, Mr. Argov. Well presented. Do we have a motion to accept this case?
I'll move.
Mr. Delaney has moved. Is there a second?
I'll second.
Is that Ms. Rosman?
Yes.
Yes. Ms. Rosman, second. Are there any comments on this case?
I'd like to make one comment.
Go ahead, Chuck.
As the board members are aware, we have a draft set of revised and new rules that we've been working on now for more than a couple of years. And one of the provisions in that is to give all owners a one-time extension, the right to make one more extension application, regardless of whether they've missed the deadline that they're applying for an extension for. And you've heard me and some of you have heard a letter from New York City Loft tenants expressing dismay at that provision and a concern that the proposed rule as it's currently before us does not carve out any exceptions for people who have kind of made lots of applications such as this. And for the public, I would just, the record for this administrative determination, including a bunch of other cases, admittedly, is 1,400 pages. It's a lot of work. And here we have an owner who seems to put a lot of energy into appealing deadlines that he, for whatever reason, can't be met. So this is just another example of the kind of extension application, administrative determination, reconsideration, appeal that leaves me scratching my head about that rule as we currently have it set forth. Thank you.
Thank you. Any other comments from anyone?
I'd like to make some comments.
Ms. Rosalind, could you just identify, that's Ms. Heather Rosalind.
Yes, Heather Rosalind. Well, given with what we were presented to read through this week prior to this meeting, even within that information, there were so many interesting and complex issues and questions that were raised, which we discussed a little bit earlier. And I found both the applicant's arguments and the Loft Board staff's arguments compelling in many cases and not compelling or convincing in many cases. And I think this could be a much longer conversation even than we had, and that in this particular case, it really comes down to this July 24th, 2019 date, which was requested by the owner. So it's a lot of background and a lot of information here that is with a proposed order that is determined by a technicality more so in my eyes than a real solid argument from one side or the other.
Thank you, Heather.
That's it.
Thank you. Do we have any additional comments? Mr. Rivera, will you please poll the board members?
Mr. Barrett,
Mr. Barwitz. Elliot.
Did you not hear me? Yes.
Mr. Rose,
Yes.
Mr. Hernandez,
Yes, you can hardly hear you, by the way.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Rosalind,
Yes.
Ms. Torres,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
9 in favor.
Thank you, Mr. Rivera. Motion. The motion is passed. There are 3 cases on the summary calendar. They're voted on as a group, and those cases are American Package Company, Inc. That's 226 through 240 Franklin Street in Brooklyn. That docket number is LS0259. The other case is Stephen Mennett, and that 239 Banker Street, apartment 4C, Brooklyn, New York. And that docket number is PO0139. The other case is Raoul Arboit, Theodore Scheer, and Aubriana McCarter at 239 Banker Street, apartment 1E, Best-in Brooklyn, and that docket number is PO0144. Do I have a motion to accept these cases? Mr. Delaney. And Mr. Hilton is seconded.
Second.
Thank you. So does anyone have any comments on these cases? No comments. So Mr. Rivera, could you please poll the board member?
Mr. Barrett,
Yes.
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Torres,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes,
9 in favor.
thank you. Motion is passed. There are 3 proposed orders on the master calendar. The first case is tenants of 475 Kent Avenue, and that address is 473 through 493 Kent Avenue in Brooklyn. The docket number TM0099. Ms. Lee will present this case.
Thank you, Chairperson Hilton. This case involves,
Ms. Lee, I think we have a very muffled sound. I don't know if everybody else is experiencing that. Could you just test yourself again, Ms. Lee?
this is a test.
Yeah. Are you calling all through your device?
No, I'm using the computer.
Oh, could you do me a favor? Could you just call in and I will let you in on the phone? Just give us a second, please. Is that you, Ms. Lee? Just say something. Ms. Lee, can you hear me?
This conference will now be recorded. Muted.
Lee, are you hearing me? Did everyone hear an announcement a while ago about the conference now being recorded? Backup recording? Okay. We have a backup recording just in case something went wrong, by the way. I didn't take it off record before. Ms. Lee, are you here? Are you hearing me? You are? Could you take your phone off mute? I'm not hearing you. 1 second. Ms. Lee, if you can hear me, could you just raise your hand? Okay, just say something. It looks like you're unmuted, but I'm not hearing you at all.
Can you hear me now?
I'm hearing you good. Thank you. Go ahead, Ms. Lee.
Okay, I apologize.
That's all right.
Okay, so this case involves a diminution of services application that was filed by the tenants of 3 residential units in the building located at 473 to 493 Kent Avenue in Brooklyn, New York. The tenants allege that they had previously entered into mutual agreements with the prior owner of the building for permission to park their vehicles inside a freight garage on the premises, and that the current owner, after acquiring the building, diminished their ability to access and use their indoor parking spaces. Opposing the tenant's claims, the current owner contends that it did not diminish any services that are required under the Loft Board's rules. This proposed order finds that indoor parking is not a minimum housing maintenance service, which the owner has an affirmative duty to provide under 29 RCNY Section 2-04B. However, the Loft Board's rules, specifically 29 RCNY Section 2-04C, are a reduction in prior services that were supplied by mutual agreement. Here, the record sufficiently demonstrates that the prior owner consented to the tenant's use of the freight garage for indoor parking purposes. There were valid mutual agreements between the tenants and the prior owner. This proposed order finds that although they exceed the minimum housing maintenance services, which are mandated by 29 RCNY Section 2-04B, the tenant's indoor parking spaces constitute prior services which the current owner is prohibited from diminishing under 29 RCNY Section 2-04C. This proposed order further finds that there has been a diminution of services. The record shows that the current owner has interfered with and reduced the tenant's access to their indoor parking spaces in violation of 29 RCNY Section 2-04C. Prior to the current owner's acquisition of the building, the tenants had round-the-clock access to their indoor parking spaces. After it purchased the building, the current owner repeatedly had dumpsters delivered to the site and allowed contractors to perform construction activities on the premises, which hindered the tenants' use of their indoor parking spaces. In addition, the current owner allowed a film shoot to take place on the premises for 4 days in June 2019 without the tenant's consent. Moreover, the current owner issued a notice whereby it advised the tenants that they were no longer permitted to park their vehicles inside the freight garage, as well as letters whereby it repeatedly rejected the tenants' payments for parking. This proposed order finds that said notice and letters constitute a diminution of services. The Loft Board has previously held, in matter of Oanesian, that where a tenant's use of his or her parking space is a service which an owner must continue to provide under 29 RCNY Section 2-04C, the owner's attempt to bar such use by repeatedly rejecting the tenant's payments and demanding that the tenant stop such use is a diminution of services. As to other encumbrances alleged by the tenants, including the replacement of a remote-controlled gate mechanism and garbage cans that were placed in an adjoining driveway, this proposed order finds that such events did not amount to an unlawful diminution of services. In sum, this proposed order grants the tenant's application and directs the current owner to cease all efforts that preclude the tenant's use of their indoor parking spaces.
Thank you, Ms. Lee. Do I have a motion to accept this case? Mr. Delaney is raising his hand. Is there a second? Mr. Borowitz, seconded. Please, any questions or comments on this? Excuse me, any comments on this case for board members? No comments? Ms. Lee, was this case ever before us? Prior?
This particular case was not before us before.
Was there, but there was a case for Kent Avenue diminution of services before us?
Yes. It was matter of Oanesian, Loft Board order number, I have it right here, 4859.
Same finding, correct?
Similar finding, yes.
Okay, Thank you. Any other questions from Ms. Lee or comments? Ms. Rivera, could you please poll the board members?
Mr. Barrett,
Yes.
Mr. Roach,
Yes.
Mr. Hernandez,
Hernandez? Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Abstain.
Ms. Torres,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor, 1 abstain.
Motion's passed. The second case in the master calendar is Kathleen Coretta at 210 Cook Street in Brooklyn, New York. Docket number is TR 1399, and this is Ms. Lee's case again.
Thank you, Chairperson Hilton. This case involves a coverage application that was filed by the alleged residential occupant of Unit 304 in the building located at 210 Cook Street in Brooklyn, New York. No answers were filed in response to the coverage application. The Loft Board staff transferred the case to oath, which assigned the matter to Administrative Law Judge Kara J. Miller for adjudication. In August 2020, Judge Miller issued a combined notice informing the owner of the building that it was in default for failing to file an answer and advising both parties that a preliminary conference would be conducted in September 2020. Neither party appeared at the scheduled conference. Then Judge Miller issued a final notice of conference informing both parties that a second conference would be conducted in October 2020. Because neither party appeared at the September conference and because the applicant did not contact oath to request an adjournment, Judge Miller marked the October conference as final against both parties. The owner's counsel subsequently filed a motion to vacate the owner's default, which Judge Miller granted. In October 2020, the owner's counsel appeared at the second conference. However, the applicant failed to appear. Therefore, Judge Miller notified the Loft Board that pursuant to 29 RCNY section 1-06K4, she was dismissing the coverage application with prejudice for failure to prosecute. Because Judge Miller marked the October conference as final against the applicant, because the applicant failed to appear at the October conference, and because the applicant neither contacted oath nor submitted a written request for reinstatement of her coverage application within the prescribed 30-day period as set forth in 29 RCNY section 1-06K4, this proposed order agrees with Judge Miller and dismisses the coverage application with prejudice for failure to prosecute.
Thank you, Ms. Lee. Do I have a motion to accept this case?
I'll motion.
Ms. Roslin, do we have a second? Mr. Delaney, I'm sorry, Mr. Delaney, yes. Do we have any questions? Comments? Ms. Rivera, could you please poll the board members?
Mr. Barrett,
Yes.
Mr. Roach,
Mr. Roche is indicating yes.
Mr. Hernandez,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Torres,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
9 in favor.
Thank you. The other case is Downing Street LLC at 53 Downing Street, New York, New York. And that docket number is LE 0720. This is a removal case, by the way, so there will be no presentation. Do I have a motion to accept this case? Mr. Barwitz is moved and Mr. Hernandez is seconded. Do we have any questions? or comments on this case? Mr. Rivera, could you please poll the board members?
Mr. Barrett,
Yes.
Mrs. Rose,
Yes.
Mr. Hernandez,
Yes.
Mr. Hilton,
Yes.
Mrs. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Torres,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
I'm in favor.
All of a sudden, Mr. Rivera has a stutter. I wonder where it's coming from. Okay, that motion is passed.
Mhm.
So that's the end of the cases. First of all, I want to say thank you to the staff. I know they've been working very hard to get these cases together, and with such limited amount of resources during this time. So I want to thank the staff, Ms. Lynn and staff, for putting this whole thing together. And so that's the end of the cases today. I want to, before we go into Mr. Delaney's portion, self-certification, I want to encourage the public to continue to sign up if you haven't done so yet for the Loft Board listserv, so you can get notices from the Loft Board in a fast and more convenient manner, right to your email. And I think it's been working greatly so far. So kudos again to staff for maintaining that list. But I want to encourage members of the public, and to the extent that you can, if you have friends or neighbors or so that would sign up for these notifications, that will increase the relevance of the Loft Board in a way for people. So just encourage them to sign up. To sign up, they just have to go to www.nyc.gov/loftboard and sign up there. There'll be a link to sign up. Thank you, Mr. Delaney. We'll now present we'll now have a discussion on self-certification and professional certification Loft Board buildings.
Okay, thank you, Chairman Hilton. I first off want to commend, as I frequently do, the high quality of the minutes of our Loft Board meetings as they've been prepared over the past year plus. And particularly the November minutes have a very useful summary of this issue from pages 10 to 14, and those minutes are available to the public, or will be. I think the draft form is up on the website even before we approve the minutes. And the reason that the summary is so good is because Ms. Rosalind and Ms. Torres-Moskovitz filled in a lot of the gaps in my understanding of the processes because of their professional expertise as architects who practice before the Department of Buildings from time to time. And the issue that we're interested in, for those who haven't heard it discussed before, is the appropriateness of both self-certification and professional certification in IMD legalization work. And I learned when we met with Mr. Martin Rebholz of Department of Buildings, who is apparently quite knowledgeable on this topic, that professional certification is actually certification by a professional who is licensed by the Department of Buildings, such as a plumber, or I guess it could be someone in the various elevator classifications. Whereas self-certification is certification of the appropriateness of plans by an architect. And I'm going to stop right there and ask either Julie or Heather to tell me if I'm got that, if there's anything you'd like to add or amend in what I've said thus far.
No, you're doing great, Chuck.
Okay. And as we learned, the department does a significant amount of random spot checking of professional and self-certification submissions, and they also investigate any complaints. So the idea that's on the table is that while mandating that IMDs, for example, not be allowed to use these certifications would require action by the city council and the mayor's office. The Department of Buildings would have it within its authority to, particularly if asked by the Loft Board to do so, to include the relatively small number of IMD certifications as part of what would be automatically audited. So that's the germ of an idea that I'm still reflecting on. But what I would like to spend a minute on today is this discussion with Mr. Rebholz came about because Ms. Torres Moskovitz wrote a letter to Chairman Hilton now maybe a year and 3/4 ago. It took us a while to get through it, but the most salient fact is that the concerns which prompted Ms. Torres Moskovitz to write that letter really stem from some egregious circumstances in loft buildings. There's one where the plans were approved for, and I'm rounding the numbers, I don't have them right in front of me, but the plans were approved for 22 units, but lo and behold, the final C of O was for 44 units. Well, where'd the other 22 units come from? We had a building where the Loft Board joined in the effort to have the certificate of occupancy revoked because the C of O was granted that had residential units in the basement. So, and there are several other buildings that seem to have been, in some instances, certifications were put forth by people that you can really only think of as bad actors. And in my mind, one architect suffered what I consider a slap on the wrist and losing the right to self-certify, whereas frankly, I think an appeal to the New York State Department of Education to look into licensure overall would have been more appropriate. But it does appear that there are circumstances about the wild and woolly nature of loft conversion and loft development that seems to attract the occasional person with a dubious approach to how to perform what should be thought of as compliance or legalization. So that's why we're having this discussion. And Chairperson Hilton was correct. I did contact him yesterday and say, having thought about this, I don't think it's fair to drop this in the lap of a new member right away. So let's leave the presentation of a resolution to the February meeting rather than today. I know if I had just joined the board and was trying to represent tenants, I'd want a little time to get my feet under me. So that's where we are, and that's what I have to say. Yes, and I look forward, Mr. Hilton, to if you'd like to discuss the matter more between now and next month, I'd be happy to chat with you.
I'll reach out.
So I'd like to add a few additional points.
Please.
We also discussed the complexities of code compliance in a building that has not been thought through from the beginning, but rather developed or built out in an ad hoc manner, and the risk of coming to a point during the construction process, if the plans are professionally certified, that something cannot be followed through because something was either inadvertently or on purpose missed by the architect, and how that could cause delays and issues with the tenants. So if, for instance, it's part of the narrative process, there's an agreement that's come to, and then if the architect professionally certifies, and then 9 months down the road it turns out that, oh no, this wall has to move, or it could be detrimental to the legalization or to the tenants. That was a big fear.
And Heather, I agree. And in particular, obviously, in regular construction of residential units, it's done before anybody moves in. Here you're doing legalization work with tenants in place, which adds another factor to the complexity.
Right, and when you have a blank slate, you can ensure that the room sizes and the windows and all of the code regulations are adhered to. When you're starting with an existing condition, there's so much minutia that can get missed in term, because one would be documenting an existing building, that there's just there's so much room for error.
Thank you.
Julie, you looked like you had something to add.
Yeah, I was just going to add, well, welcome, Christian, to our board. It's great to have you. It's good to have every position full. I would just add the point of view from the owner's perspective too, because as an architect who works for clients that are owners, actually I've never had a tenant as a client, but I am a Loft Law tenant, just so you know. So I think there's both perspectives at play. Like for an owner, this could lead to a lot of hardship down the road if sort of this maverick professional certification of a complex building with tenants in it needing law certification also goes all the way through to construction or midway, and they, there's a stop work order, a violation, and they find that, or audited, and you find out that actually this decision that the architect took into their own hands is not what the DOB believes is the correct interpretation of code, that I feel like it could lead not only to tenant issues but also to cost ramifications for owners of buildings too. So that was what I wanted to add. And I could also send my letter, maybe Ronaldo, or I don't know if you would, to Christian, so he can see the original letter I wrote in 2019 or 18.
Sure, I'll send it right after this meeting to Christian.
Okay, thank you.
Maybe I'll just send it to everyone.
Okay.
Thank you. Are there any other comments? Thank you. So, so just to recap, Chuck will attempt to do this through a resolution to Department of Buildings, a non-binding resolution to Department of Buildings regarding, and which we'll vote on obviously in February. And the language, I guess, Chuck, you will try to circulate some language prior to this?
Yes, I will do that, and we'll attempt to have it to people 2 weeks ahead of time so that they have a chance to look at it.
And thank you for that, Chuck. Thanks for the opportunity and the respect to Mr. Hilton to chime in. Okay. Thank you, Mr. Delaney. We're now going to go into a second part of our meeting, which is rulemaking. Before I begin that, I just want to, I know last month, maybe it was the holiday spirit and stuff in me, but I did kind of say something like, I hope, and we're hoping, and we probably will have rules ready by April. I could have not necessarily misspoke, but just out of abundance of optimism there. I'm not saying it can't be, but it doesn't seem that April is any longer a reasonable time frame to get final rules. But we're working hard at it, and it all depends on how quickly we move. But more realistically, towards the summer, the summertime would be a more realistic time frame for us to get through the rules. And then again, it all depends, of course, upon the law department's review and also your actions and in moving this step forward. Did I get that right, Ms. Lynn? Okay, great. Okay, Mr. Clark, who's been doing an exceptional job with this, is going to take over from here. And just so we know, we're going to try to do this by 4 o'clock, an hour spent on rules. Yeah, Mr. Clark, is that good?
Sorry, Chairperson. Before Mr. Clark begins, I just had one item to discuss with the board regarding rulemaking. I would like to ask the board members if they would like to revisit Rule 2-01B for next month's board meeting. Mr. Delaney actually referred to this earlier. So currently 2-01B3 of our rules say that the owner can only receive one extension of code compliance deadlines per deadline. So once the owner has received an extension of code compliance deadlines, they can't receive a second one, even if it's not their fault that they can't proceed with legalization. So I believe that the board had previously discussed this issue in maybe 2019 and came up with new rules for this. So under our current proposed rules, 2-01B4I, the one extension per deadline rule is removed. And under the newly proposed 2-01B1, within 30 days of the enactment of this rule, any owner can reapply for an extension even if they were previously denied. So after the board voted to send the rules to the law department and operations for review, a group of law tenants submitted their comments and their own proposal on these provisions. The tenants are asking to restrict who can reapply and to keep the one extension per deadline rule. And those materials were circulated to the board in March 2020. But at the time, because the rules were already being reviewed by outside agencies and because we didn't have an owner's rep at the time, the board hasn't had the chance to revisit this topic yet. But now the rules are back before the board and we have a full board. So if the board members are amenable, we can place this topic back on the agenda for the February board meeting. And I can recirculate the tenant's proposal after this meeting so the board members will have a month to review and consider the material.
Thank you, Ms. Lynn. I did have that to call on you to do that. I'm sorry for overlooking. So yeah, so this is just advising the board that we're doing that, right? We don't need, I don't necessarily need any comments on this. We're going to bring it before the board starting February.
Well, you certainly get my thanks.
You can. I'll give you my routing number and bank account number after this meeting, Mr. Delaney, off the record. Okay.
I think Rich has a question here.
Yes, Rich, go ahead.
Mr. Chairman, I just wondered if you anticipated any additional meetings this month or in February for rulemaking purposes, or is it too early to make that determination?
Okay, so I'm not doing it for this month for sure, and I don't think I'll do it for February. So let's see how we move along. But in order to really expedite these rules, depending on how we are, we can possibly look at March and April for additional rulemaking meetings if we have a quorum. So yes, I think Mr. Roche, you should probably anticipate March and April, if everyone is amenable.
Thank you, Mr. Chairman. Thank you.
Any other comments? Thank you. Mr. Clark.
Thank you, Chairperson Hilton. I just want to make sure everybody can hear me. Am I clear? Any issues? Okay, great. All right, so, excuse me. This morning, I sent out an email that has all the documents that we're going to be using today. I'm sorry about the last minute me sending the two of those documents, but those two documents are more so just to make it easier for everybody to follow along with what we're doing today. One of the documents we're going to start with is a document that we've already been using. This is the for Mr. Hilton, who's joining us now as the owner's rep. We've been getting a series of comments from OATH. That's the Office of Administrative Trials and Hearing. I'm sure you know, but they wanted to weigh in and comment on the portions of our rules that affect OATH. So they did in fact do that. They sent us their comments, and what we're doing now is we're reviewing the comments from OATH, and the board members must decide if they're okay with the comments from OATH or if there are any changes that they would like to make. So we've been working off of the sheet. At the top of the sheet, it says 1-12 definitions. And everything on this particular document, the board members have agreed with, except for 3 points. And our goal today is to try to go through those 3 points, and if possible, get back to OATH after this meeting and let them know what it is the board members have accepted and what it is the board members would like to change. So there are three, like I said, there's 3 issues that are still outstanding with respect to the OATH rules. And I would like to go into the first outstanding issue. I would like to go into 1-31, which is decisions. 1-31 under decisions, section C. This particular issue, Mr. Delaney wanted to us to look at a little bit further. This section says that the report and recommendation that the administrative law judge issues, this says the report and recommendation that the law board adjudicator must include, and it lists certain things that the report and recommendation must include. Mr. Delaney wanted to us to look at the current reports and recommendations that OATH gives us and make sure, just to make sure that the current report and recommendations that OATH is already giving us includes the information that's listed under subsection C. So the other document, another document that I sent, at the top of it, it starts with tenants, and it's a report and recommendation. It's kind of a abbreviated report and recommendation, and I thought it would be easier for everybody to see what some of the information that's included in the report and recommendation that OATH currently gives us. And I looked through it, and all of the subsections of C that are in our proposed rules, OATH is already including them in our report and recommendation. And I can just walk you through that briefly. Like I said, it's just a shortened version. If you want to read the entire report and recommendation, you can find that on the New York Law School website with our proposed orders. They do have the report and recommendation that OATH gives to us that we use to make our proposed orders, and that the board members actually use to make their final proposed order. So at the top of the sheet, you can see OATH includes the OATH index numbers. They also include the Loft board docket numbers. And that goes to number 1 on subsection C, where it says the report and recommendation must include a description of the application, the names of the parties, their counsel, and other persons affected by the application. So at the very top of the sheet, we have OATH identifying the index number, the Loft board docket number. Below that, there's a short paragraph with a description of what the case is about. And immediately below that, the parties are listed for this particular application that was submitted. If you flip to the last page of that sheet, at the very end, oath will always include the attorneys that are involved in the matter. They'll list any pro se litigants that are involved in the matter. So all of that information is included in the report and recommendations that we're getting from oath. And anybody can stop me at any time if they have any questions. So that checks off number one. Number two, the report and recommendation is supposed to include a summary of the facts disputed and the facts found during any investigation of and of test or testimony and other proofs taken at the hearing or inquest. So at the very beginning, again, going back to that first page, the report and recommendation, the administrative law judge will immediately go into the procedures of the case, the factual background of the case, and then we'll proceed to do a full analysis of all the factual information that can be, all the factual information that was discovered during the hearing. So I don't have, this would have been 15 pages for all of you to go through, so I don't have, you know, all the facts, the additional pages, and the complete analysis, but that is what oath does regularly with their report and recommendations. They list the factual background and then they do an analysis. So that is checked off for number two, a summary of all the facts and all the investigative information. The third part, the number three, the report and recommendation must contain copies of the application and of all affidavits, memoranda, and briefs submitted by the parties. So what happens after oath submits their report and recommendation, they will send back the entire record to the Loft Board. And that record does in fact include any affidavits, memoranda, post-trial briefs, and exhibits. The Loft Board staff has that, and we use that information to write the proposed orders that we bring to you for your vote. So that is there as well. And then the final issue number four, the report and recommendation must include a recommendation to the Loft Board regarding disposition of the application with the summary of the factual and legal basis for such recommendation. Again, the oath ALJs do a fantastic job writing up summaries, the factual and legal basis, and coming up with an analysis. If you flip to the second page of this document, towards the bottom, it says findings and conclusions. There's where you find the ALJ basically summarizes the findings and makes a conclusion and a recommendation to the Loft Board. You can see from the second page going on to the third page, at the very end of all the findings, in this particular case, the ALJ says, accordingly, the party's application should be granted. And that's their recommendation to the Loft Board. So with respect to doing this research here, we feel that the current report and recommendations that oath is providing to us does in fact include all of the information that our proposed rules is requiring. And I just wanted to give anybody an opportunity to comment if they had any questions about that. But that was one of the outstanding issues with respect to oath's comments.
I think it's time for me to say thank you.
I'm sorry, I didn't hear that.
I said, I think it's time for me to say thank you again.
Oh, no problem. Okay. So that
Stefan, something going on with the device. Is there your muffled?
No, that's going on with your mic too.
My mic also?
Yeah, I'm hearing a reverb on your end as well.
Okay. Stefan, let me test you first. Go ahead.
Okay, can everybody hear me clearly?
It got suddenly garbled.
Okay.
Oh, I'm all echoed too. Ronaldo, did you hit the wall pedal?
Unlock? I'm sorry, go ahead, Heather, I didn't hear you.
It sounds all, it was all, oh yeah, it's better. It was
Better now.
echoey for a minute.
How about me? Is everyone hearing me? Okay, because it's all about me. Stefan, can you just speak?
Sure. Is this any better or is it still terrible?
I don't know. It's really bad.
Okay. I'm gonna call it.
Yeah. Please.
To enable audio control.
Ronaldo, I think you have to unmute caller 17. I think Stefan's dialing in.
Stefan?
Okay.
Stefan, could you turn the volume on your device down and use your phone?
Stefan, I think you have to turn off the sound on your laptop and listen in on your phone.
Yes. Can you guys hear me now?
Right. Excellent.
Okay.
Thank you.
Perfect.
Okay. So I think Mr. Delaney just stepped away for one moment. So once he returns, we'll pick it back up. Or if you want me to wait.
I think he had just said I think he had, correct me if I'm wrong, he said he was saying thank you before.
Okay.
But we could,
Okay.
Does anyone else want to have anything else to say about what Mr. Clark presented so far?
Okay. Since I know we don't have that much time left, I'll go ahead and we'll go into the next document, which is the comparison. This is the larger document that was sent. And this document is actually another request from Mr. Delaney. And this request is under 1-27 hearings. This is section E. And the reason why Mr. Glenn Argov, he undertook the task of comparing oath procedural rules with the Loft Board rules. Under E, it says that oath hearings, where oath conducts a hearing and the Loft Board rules conflict with oath's procedural rules, oath's procedural rules of practice will apply unless otherwise provided by law. Then it goes on to say, where there is no oath rule or practice regarding a procedural issue, the Loft Board's rules will apply. So the reason why Glenn took on the task of putting this comparison sheet together is Mr. Delaney wanted to find out the differences between oath procedural rules and the Loft Board's procedural rules. Because what would happen if the Loft Board members accept the change in the rules in our rules under 1-27 hearings, then what would happen is as soon as we send our cases down to oath, all of oath procedural rules will govern. If there's a conflict, if the law board rules and oath rules conflict, oath procedural rules will govern. If there is an issue that arises where the oath rules are silent, then the law board rules would apply. So this sheet that we have has various procedural issues that might come into play where there's potentially a conflict between oath procedural rules and the law board procedural rules. And I just want to, before we go into this document, I'm just going to go through each of the issues here. I think there's about, there's 13 of them. We'll get through them, but I wanted to make sure that everybody had a time to just familiarize themselves with this a little bit, and then also just to also explain that the only time this comes into play is when the law board sends our cases down to oath. So when somebody files an application with the law board, there's various phases that this application goes through. The first phase is the filing, where the parties file the application. The opposing party has time to answer. There might be some amending going on, but that's phase one. That's not at oath yet. Phase two is when, after the law board makes sure that we have the applications, the parties have answered, there's proper proof of service, all of our rules would apply to phase one. Phase two now is when we actually send it to oath to adjudicate the matter. And this is where procedural rules might conflict. So I just want everybody to keep that in mind. After phase two includes when we send it to oath, up until oath writes the report and recommendation and sends it back to the law court. After that, I guess you can say phase three would be the law board staff going through the information and writing our proposed rules, submitting that to the board members for their final order. That's phase three. And then the last phase is any type of appeal process that might happen. So we're really, again, looking at phase two, when we send it to oath, in that time period between when we send the application to oath and when oath writes the report and recommendation. So the very first issue that we have on the sheet, and Glenn can always chime in.
Could I interrupt for 1 second?
Sure.
Just for the, first off, thank you for doing this. And Glenn, I know this was a significant undertaking and I very much appreciate it. But just for some of the newer members, maybe it would be worth pointing out that when a case finally goes to oath, it first goes to a settlement judge who attempts to see if the issue can be settled via conference. So my question to you is, do any of these procedural rules apply to that period, or only if, when the parties can't agree, as I understand it, it then goes to a different oath judge for a trial? The theory being that the settlement judge may have been party to discussions that would have exposed him or her to issues and questions that would not be appropriate for somebody who's now going to actually try the case.
Thank you, Mr. Lane. That's a great question. Acting Executive Director Lynn can chime in, or Glenn can chime in, but I think that would still fall within this purview of the oath procedural rules applying, because that's no longer in the law board staff's. We wouldn't be handling any of that. We never know when that's happening. So that's all oath undertaking. So I would I would assume that would fall underneath oath procedural rules as well. But Executive Director Lynn, I'm not sure if you have a difference of opinion, but that's what I
No,
believe.
I agree. I think once it's before oath, including the settlement portion, their rules would apply, and some of these rules probably would apply. For example, oath has rules on who can appear before them, and I would think that their procedural rules would apply at settlement conferences as well.
But Mr. Delaney is correct in that the settlement judge is not the trial judge.
Yes, that's correct.
Correct. Okay. So
Go ahead.
if there are no further comments, we can get right into this document with the first issue. Page 1 is the computation of time. This is basically whether or not, so the computation of time for both the oath rules and the loft board rules, it basically is how much time do the parties have to do something. The oath rules are, they talk about calendar days, and the loft board rules, they speak on business days. And then loft board rules further define business days as from ending at 4 p.m., from 9 a.m. to 4 p.m. And that's the only difference with the computation of time, in that if something happens when the case is before oath, the computation of time is going to be calendar days as opposed to business days, but we don't believe that has any real effect on anything. But calendar days is different from business days. Business days being defined as 9 a.m. to 4 p.m. But oath rules would apply if the case is before oath at that time, and there's a certain amount of time that the parties have to submit or do something. Oath rules would apply, and that would be calendar days.
Just to clarify, Mr. Clark is referring to the comparison between OATH's current rules and our current rules. Our proposed rules do actually go on to say calendar days. And again, as Mr. Clark pointed out, it's just a difference in terminology. It seems practically the effect would be the same.
Yes, you're right. Thank you, Executive Lynn. Yes, our new rules do say calendar days now.
Meaning that we are adopting oath's procedural.
Right. It practically, for all intents and purposes, would be the same. Okay. If there are no issues with that, we can move on to the second issue, which is Oath Rules 1-07, filing papers and proof of service. For the most part, when somebody files an application with the loft board, that is not before oath at that time, so the loft board rules would apply with respect to filing the papers and the proof of service. But there might be instances where the parties need to file when the application is before oath and they need to submit proof of service. So then oath procedural rules would come into play and apply. So as stated on the sheet, oath allows electronic service, and that is one of the major differences between oath's rules and our current rules. However, our proposed rules, actually no. Okay, sorry. Let me break this down into two. First is the service, the actual service. Oath allows electronic service. And our rules, I don't think they've changed our proposed rules.
No, Stefan, we did change that. The service, we are trying to allow for electronic service now. So
yes.
Once the proposed rules are passed, it would conform with the oath requirements on service and what's allowed.
Right. Yes. So then both of those, the service
would allow electronic service, yes. So those two issues look the same, and we don't think there's any conflict there. Proof of service is the next part of that rule. And the proof of service is oath requires an affidavit from the person affecting service or acknowledgement by the person receiving the service. Our proof of service under the proposed rules, our proof of service again allows for the email, fax, and first-class mail, and private delivery. So there is a minor discrepancy between these two. With respect to proof of service, it would, if the case is before oath procedural rules would govern, and oath requires proof of service in the form of an affidavit by the person affecting service or acknowledgement by the person receiving service. So that's the only, and Executive Director Lynn or Glenn can step in, but that's the potential conflict that might arise, and oath's rules would apply in that situation. It's different than our rules, but if it's before oath, proof of service that oath requires is an affidavit by the person affecting service or acknowledgement by the person receiving service.
What is in our proposed rules again?
It requires something a bit more, either an email or fax delivery receipt, so something other than a statement saying that you did it or an affidavit. And just my 2 cents, I'm not sure if it has really any prejudicial effect, this difference, because again, the applications that are filed with the Loft Board are filed with the Loft Board, and we're still going to require them to provide these, fax delivery receipt or an email or certified mailing receipt. So that's all still Loft Board rules. What's being filed before oath, what this would dictate would be things more like motions and memos that they file with the parties already before the oath judge. And I think there's probably, in my opinion, less of a concern of requiring a very specific proof of service.
So no big deal there, right?
Not in my opinion, but of course I'm open to hearing thoughts from the board members.
All right, I like no big deal because we got to get through this. All right, let's go on.
Okay. If there are no comments, we'll move on to the next one.
Can I?
Oh.
Yes, I want to recognize Chuck first and then Heather.
Sure.
Okay, so Tina, you make an important point there. Our rules would remain our rules for the inception of the case until we hand it off to oath. But then for subsequent filings, there'd be oath rules would apply. And obviously part of my interest in understanding the difference between the oath procedural rules and ours is, and I think it's true for practitioners, whether they represent tenants or whether they represent owners, they've been used to doing things a certain way in the Loft Board, and I'd hate to see clients be affected negatively because there's a different rule now that somebody hasn't had the chance to get up to speed on. So actually for this, we'd still have kind of a parallel universe where our rules would apply until the handoff, and then a different set of rules would apply.
Yes, Mr. Dillon, I think that's correct. So in terms of actual service, the method in which you can serve, I don't think there'll be a difference because now we're going to just allow for electronic service, same as oath. The difference comes down to what proof of service is required. And I think that's an easy fix. And I'll just mention that I think oath's rules are less onerous than ours, and that oath isn't requiring them to hold on to any receipts They're just requiring an affidavit or acknowledgement of receipt, which I think is a lower bar. I do feel like if people can get through the hurdle of filing an application with the Loft Board, they can certainly effectuate proper service at oath, which is, as I understand it, often in email service is acceptable.
So then in your take on the matter, the oath rules are easier, so the likelihood of anyone getting caught on this particular aspect is low.
Yeah, that's my opinion. And from what I understand, I think the ALJs are pretty good about explaining things to pro se.
Okay, thank you.
I think Ms. Rosalind had a comment as well.
And a question. So one purpose of this exercise is to ensure that that none of the conflicts are detrimental or egregious as to cause a real issue, right? And then, am I correct that, so we have no say over oaths rules, obviously, but are we also wanting to understand maybe if there are some places where the two can come closer together? I guess that's a question to the rest of the board. Is that something we want to pursue? Do we want to have a discussion about any of these conflicts to see if there is a reason why we might want to alter our rules slightly to be closer to oaths rules? Or are we just making sure that there are no unforeseen issues that would arise out of these conflicts?
I believe it's the latter. We're just trying to ensure that the oaths procedures isn't going to be detrimental to the people who appear before them in any way, now that there's a difference of rules.
Okay.
So the point here is, I'm sorry, did I interrupt someone?
Oh no, I saw Ms. Torres Moskowitz raising her hand. I was just acknowledging.
Okay, go ahead, Julie. I'm sorry. Go ahead.
All right, thank you. I was just wanted to make sure you guys are more in this chart than I am. I love it, but I want to make sure I'm understanding it right, because I have the perspective of actually being a tenant, loft law tenant. And one of the things I like the Loft Board does is communicate with other tenants that aren't Loft Board tenants, so that it makes them aware of things happening. Does anything change with that? I think that's what the certified mail does, is it informs everyone else in the building so that even if they're not involved in the case, they have a chance to understand what's happening in their building. Does this affect that at all? The ability of a tenant who's not a loft law tenant and not an IMD, or who's in a building, does it affect their ability to learn information or no?
So I believe this would fall under, again, initiating the application, which would fall under our jurisdiction still. And our rules still require them to serve affected parties. So the people in the building would be served with a copy of the application.
By digital means or electronic means? I'm just wondering.
So right now, we don't allow for electronic service, but if our proposed rules pass, it will allow for digital service. Yeah.
So if you had a building, let's say with 48 tenants and only 10 of them are loft law tenants, you would have to, Loft Board would have to figure out everyone's email? Or am I getting this wrong?
Well, for the filing of the application, it's the party who initiates the application that will have to do that. And they don't have to file by email if they don't want to. They can certainly still, serve. They can certainly still serve by the regular methods. If they choose to, they could, and if the other party consents, they can serve by email under the proposed rules.
Yeah, it's important to note too that the email service is by consent only, correct?
So that's something that we're actually going to get to in our rulemaking. I believe in the version that the board passed back last year doesn't have the consent provision. When we were doing the emergency rulemaking, this issue came up. So that's part of the emergency rulemaking on electronic service. So now we have to go back and incorporate that into our regular rules.
Right.
Can you say that again, please?
Yeah, sure. So the issue is about whether a party needs to consent to email service before they actually, before email service becomes effective. So back in February 2020, when the board first passed the draft rules, consent was not something that was mentioned. And this issue came up during the course of the emergency rulemaking over the summer in response to address the pandemic. The board passed a set of emergency rules providing for electronic service. And it was pointed out, I don't recall by whom, possibly law department, that the tenants or owner should consent to service before we can make electronic service a thing. So we went back, so in the emergency rules that we passed over the summer, consent of the parties is necessary before you can actually serve electronically. So our current proposed rules don't reflect that, and that's something that staff still has to work out on how to incorporate the language.
Thank you.
Right. Okay, are there any other questions? Okay, I'm sorry. Are there any other questions or comments on this issue? Or can we go to the next one? Okay, so we'll go to the next issue, which is appearances. That's 1-11A for the oath rules. And the difference between the oath rules and the Loft Board rules are the oath rules, they seem to allow non-attorney representatives to appear before oath. And the Loft Board rules, it appears they don't contemplate non-attorney representatives appearing at a hearing. I'm not sure. I don't think that's. I'm not sure if that's considered a major issue, but at the very least, the oath rules are more liberal, and non-attorneys can appear during the oath
Clark,
meeting.
this says in our proposed rule, it says the parties may be represented by counsel. Does that mean? Does that may kind of mirror the proposed rules?
I'm not sure if that may means the parties can either have the option of representing themselves, or they may be represented by.
Well, I mean, the plain reading of the plain language, right? That may means that you have an alternative, right?
Yes, we do have an alternative, but we're not sure if an additional alternative is to have a non-attorney appear on someone's behalf.
Is there a specific bar that says so?
No, there isn't.
I don't see how else we can interpret this.
It could be interpreted as the party may represent themselves. So OSIS rules explicitly authorizes representation by someone who is not an attorney, and our rules just don't explicitly say that. Our rules are a little bit ambiguous on that provision.
Okay, so leave it ambiguous. I mean, right?
Also,
right. Well, the only point of this exercise is to point out that there's no serious prejudice to the parties by us allowing oath to apply their own procedural rules.
Right. It's fine.
Okay.
Everyone agree
Are there any
there? I mean, I think there's anything here really to.
Okay. Are there any questions about that? Basically what what Executive Director Lynn said. We don't believe there's any prejudice to applying oath rules.
Stefan, Mr. Bowers is gonna.
Oh, I'm sorry, Mr. Barowitz, please.
This seems to occur
Elliot, could you speak up?
quite often. It means the same.
Elliot, could you speak up? Elliot, could you speak a little closer into your mic? We're not hearing you.
You don't hear me?
Yeah, just keep where you are right there and speak. Yeah, you were not hearing before. Go ahead.
The word counsel, they use the word attorney. This seems to occur periodically. There's some words that have the same meaning, and it's a little confusing to have those terms in there, where one says attorney, the other says. On the other hand, lawyers on the board.
Mr. Bowers, I'm sorry, we're not hearing you.
I don't know what the.
I don't know if you could maybe try your volume on your device. Just, I don't know. Are you on a
full force? Can you hear me now?
Is everyone hearing Mr. Bowers?
I'm very low.
I don't know why. All right, forget it.
That's good. That is good.
Oh, you got me now?
Yes.
Repeat myself the third time. We use the word counsel. Then use the word attorney. The lawyers on the board here, does counsel always mean attorney? Always mean a lawyer?
Question is, for those who didn't hear, he's asking if the term counsel and attorney are synonymous.
I believe they are.
In my experience, they've always been interchangeable within rules and administrative code.
What do you say?
Okay. Are there any other questions or comments?
Christian, Mr. Bowers didn't hear what you said.
Oh.
No, sorry. I said, in my experience, they've always been interchangeable within the rules and administrative code.
So that's a yes, Mr. Bowers.
Okay. Mr. Delaney?
I guess the question I would ask then is maybe this is an example of an instance where we might want to consider changing our rule to comport with oaths. And I'm thinking in particular that it's possible that someone could have limited English ability, for example, and would want someone to pose questions or act on their behalf who can provide some translation services. You know, some of us are getting up there. I might start to slip a little and just need a little help, not a high-priced attorney, but somebody to just tell me to give me an elbow in the ribs when I say the same thing for the 5th time.
But Mr. Delaney, I believe the proposed language right now does just that. It gives an opportunity. I think this was just this proposed language was just meant to simplify what the current rule says, is that you afforded the opportunity to be represented by counsel, and then parties shall be advised that their rights to be represented by counsel. It's the same as saying you may be. That's my point before, Mr. Clark, is that the word may there just means that you have other options. Counsel is one of them, or an attorney is one of them.
We agree that
It
that
doesn't.
they do have options where it's just not clear what those options are.
What other? Okay, so I would exclude animals and so on, right? But if you say here that you may be represented by counsel, and you say, well, I don't want to be represented by counsel, then you pick and choose. Who else do you want to? I don't think it conflicts with Oath's language here. It certainly simplifies the other rule just for plain language. I think this was just plain language revision here. I don't think there's any conflict, in my opinion.
Well,
so I don't see.
Doesn't it leave some ambiguity about if the person does actually represent the applicant or the whoever, or does it need to be the same person? Can I have my friend come next week and my mom show up the week after and my next door neighbor the week after?
Right. So
Does anyone have any experience at adjudicative experience here? Can you let me know? I don't know if you can switch representatives, but I don't think it really bars. I know in ECB court, you can at any time you can choose whoever you want to appear. I don't know how it is at Oath. But
these hearings
I want to point something out before I give anybody a chance to say. I want to point something out. In Oath's rules, it says, or by a duly authorized representative. So it seems to me that Oath does have some restriction on who may appear there, right? It says a duly authorized representative, meaning that maybe you have to be authorized. Maybe you have to have some sort of a registration with Oath to appear. I'm not sure if anyone here can opine on that or inform me, but it seems that they're more restricted than our rule.
I think I interpret that as duly authorized by the litigant. Like you can designate a representative. I don't believe like you need a license to practice before oath. I'm pretty sure you do not need a license.
Okay, I'm pretty sure of that too, but I wasn't sure what that means.
To go back to Mr. Delaney's point of whether we should expand our rules, there would be an easy fix if the board wants to do that, to explicitly authorize for non-attorneys to represent litigants if hearings ever fall back under law court jurisdiction. We could just amend 1-27C to now read, at the hearing, the parties may be represented by counsel or by a duly authorized representative to conform with what oath has to allow for non-attorney representatives.
Right.
Yeah, that's simple enough. So in the interest of time, I think that's fine. Yes.
Yes, that was what I was suggesting, and it might be helpful. To my recollection, through all these years, we once had a tenant attempt to represent himself who was clearly challenged in one or more ways, and it's possible that there might be a friend or a neighbor who could assist without being as costly as an attorney. So I think if there's a way to authorize someone, that's a good idea.
Okay.
Thank you, everyone. If there are any more comments, are there any more comments?
I have one more comment on that.
Go ahead.
I would only say that it is also important that applicants understand, especially even tenants, they're entering a potentially quasi-judicial board, and they do not wish to, they may want to avail themselves of legal representation. You don't want to give an impression that this is something less than what it is, and that there will be legal interpretations that they may want to consult someone with before if they are choosing to represent themselves. Obviously in court, a person can represent themselves pro se, but you understand what the jurisdiction is and you understand the ramifications of that. And I think one of the things in terms of how the language is currently placed, it says you may, but it kind of that inference is that you probably would want an attorney to represent you on some of these matters. And I think it's important that persons understand the gravity of the situations in terms of they enter. When I practice before oath, and you do have to represent that you represent the applicant even as an attorney. And if you're not an attorney, you have to have some particular link to the property itself and some type of authorization in terms of when you're appearing in front of hearings there. So it's not just that anybody can come and represent anybody else, interchangeably, hearing to hearing. So I would just bear that in mind.
Are you proposing any particular change to the language that would bring out your point? Are you saying the word may here may say something different?
No, I'm not. No. I was just bringing something to light.
Okay. Yeah, great. Because I was going to say maybe at the hearing the parties have the right to be represented by counsel or duly, maybe that's probably a better.
Would be, have the right would be a way of putting it.
In the interest of time, guys, I think this, if we could just replace the word may here with at the hearing, the parties have the right to be represented by counsel or by a duly authorized representative. Is that okay with everyone?
Doesn't right to counsel imply that if I'm indigent, I have to be supplied with a counsel?
Oh, I don't know that. Can you, Christian? You're the lawyer on the board.
Offhand, I can't speak to that. Out of mine, I would defer to counsel for the Loft board.
Yeah, I have no idea. It's an interesting point. I don't know.
Well, yeah. I know that in housing court now, there's a right to counsel initiative that currently applies to a limited number of population districts where it mandates that a lawyer be supplied if the tenant can't afford one.
Actually, that's a good point, Mr. Delaney. Because if I think about, I watch a lot of cop movies and stuff. You say, when they're making an arrest, they say, well, you have the right to remain silent, or you have the right to an attorney. So maybe we want to back off from that. Just after thinking twice about that.
This brings it back to May.
Yeah. Okay, let's move. We got a proposed at the hearing, the parties may be represented by counsel or by a duly authorized representative,
right? Okay, I got it. Okay, so the next issue is ex parte communications, and oath deals with that issue in section 1-14. Our analysis is that both of the rules are similar, both the oath rules and the law board rules are similar, and that ex parte communications are not permitted. In our current rules, we did have a section, in the proposed rules, we did have a section where we allowed for, there was a section about the law board. A member shall not communicate with any member of the, in the proposed rules it said the law board staff conducting the narrative statement, and we already addressed that and we already removed that section because we found it to be confusing. But other than that, it seems like the language, there's nothing conflicting between oath and the law board rules. Neither of them allow ex parte communications. But if anybody has any questions or comments, they can address them now. Okay. If there are no comments, then we can move on to the next one, which is amended pleadings. It's Oath Rule 1-25. In my reading of this, there might be a potential conflict if the case is before oath. If the parties want to amend their pleading, they have to amend 25 days prior to the start of trial. But the Loft Board rules allow the parties to amend the pleadings at any time up until and even including the date of the first scheduled conference. So there might be a possible, in my reading of it.
The amended piece, the proposal?
Yeah, the amended pleadings.
I got it.
Yeah, it's our proposed rules allows an applicant to submit an amended pleadings at any time up until and including the date of the first scheduled conference. But oath has a time limit. They have to amend it 25 days prior, unless they get the consent of the parties or the approval of an ALJ. The parties need to amend their pleadings 25 days prior to the start of trial. It's a slight difference that, you know, it's noticeable, but I don't think it's prejudicial to anyone. I'm not sure if Glenn or Tina disagree with that.
No, and I would just point out that our rules really only apply to the first scheduled conference. Thereafter, you need the leave of the adjudicator in order to amend.
Okay, are there any comments? Are there any comments on that?
Nope.
Okay, the next one.
I'm sorry, no, I had my hand up. This is the first. Question first. Is it our intention to stop at?
That was my intent. I mean, is anyone objectionable to going for another 15 minutes?
Well, my comment was going to be, this is the first one of these that came up where I would like to get some input from the practitioners before I sign off on this one.
Okay.
And
So we can just leave this one.
And I appreciate that this is work product, so I have not shared this document with any of the practitioners, but this is the first one that kind of had me thinking I'd like to get some input, which I will do without sharing the document.
So we can leave that as an open item, correct, Mr. Clark?
Yes.
Okay.
Okay.
It's not 1 second. It's not 4 o'clock. I said what I said, and I wanted to ask if there's anyone who's objectionable to going through to 4:15. Very much for your patience, guys. Just let's try to get as much done by 4:15.
So okay. we're leaving 125 open.
Yes.
Yeah.
Okay.
Okay. The next one, 126 might be might speed up the entire 15 minutes that Mr. Hilton, Chairperson Hilton, just gave us. I'm not sure if we should leave that one as an open item, or should we just try to move through that one now?
No, let's skip 1-28. That one does probably require some discussion. So if we're going to take up the oath rules again in the next board meeting, let's table that.
Okay. You said let's table it, right?
Yeah. So at the next board meeting, just to clarify, we will revisit 1-25 and 1-28.
Okay, great. Okay, so the next one will be 1-31. and that's the settlement of conferences and agreements. And both of the rules are similar in that they require an agreement to be reduced into writing. But the Loft Board rules are go a little bit further and require review by the executive director. But there's no conflict at that point. So Loft Board rules will apply, and that's something that we're already currently doing with our settlements and our summary cases. Are there any questions or comments? Yes, Mr. Delaney.
I think this is worth spending a moment on, particularly for the benefit of the newer members. You can see that in the box marked difference, the last sentence points out that the new rule includes additional language that states the Loft Board must reject settlements that include terms which violate public policy or those which are void and unenforceable. And this has happened a number of times in the last 5 or 6 years, I'd say, where owners and tenants have come up with ideas like, okay, you withdraw your case, we won't be governed by the loft law, but I'll give you 10-year leases and you'll give me 8 years to bring the building up to code instead of the more stringent rules mandated by the loft law. And we have rejected those as being against public policy. We've been taken to court, and I believe we've prevailed in all those cases. And obviously, I believe that we can't allow some parallel universe where tenants and owners agree to be bound by a set of rules that don't relate to a state law or the city's administrative code, even though there are times when there are tenants who have not been pleased with me taking that position. And there have been also many times that tenants and owners come up with a stipulation which includes some provisions that either make no sense or bind the Loft Board to do certain things. And the Loft Board has come up with an approach to say, we accept the settlement, but we neither accept nor reject the terms of the settlement, which is something that those of you who've been on the board for a while must be so sick of hearing me object to every time it comes up. We didn't have any on this docket, but if there's any way that we can, I think it's important that we include what we put in involving our attitude toward things that violate public policy. And since ultimately the case comes back to us to approve or reject or modify or send back to oath, we have the final say. But this is an area that I think would benefit from some discussion and perhaps scrutiny.
I agree with Chuck totally. When this first law came into effect, there was a substantial number of tenants that made deals with landlords, and in fact, they preferred to live together than legal. And I don't think there should be an escape hatch here. I mean, we now know it's against public policy, but we really have to make that very clear. Either we're bound by the law or we're not.
Okay, thank you. Are there any other comments on this section? Okay, so then we can move on to the next section, which is 1-32, adjournments. So the difference between the rules, the oath and the Loft Board rules, is the Loft Board does not allow more than 2 consecutive adjournments unless the party requested 5 days in advance. at which point it may be granted. But oath rules do not specify a limit on adjournments, basically. That is the only difference. We don't believe there's any prejudicial effect. It is a difference, but if it's before oath, the oath rules would apply, and oath doesn't limit the amount of adjournments that can be allowed. Are there any comments or any?
Limit? Why do we have this limit? Do you know where that came from?
I'm not sure why the Loft Board decided to impose limits on adjournments. Usually a limit on an adjournment is to make sure to streamline the process and not unreasonably delay the trial or the hearing. So I can see why there would be a limit, but at oath, their rules just don't specify a limit on adjournments. They give the control to the ALJ, who has the latitude to, based on their discretion, can decide if there's any type of unreasonable delay or any type of reason why they're no longer going to grant adjournments. So it just basically gives the ALJ that control with oath. Are there any other questions or comments? No? Okay. So we're almost there. The next one is 1-43. This speaks on subpoenas. And the Loft Board rules allow the parties themselves to issue subpoenas, where the oath rules require the ALJ to issue it. That's the conflict. Basically, when it's before oath, the parties have to get the approval of the ALJ, and the ALJ has to issue the subpoenas. We don't believe has any prejudicial consequences to that, but if anybody has comments, we'll listen. Anybody have a comment or question?
This is another one I'd like to ask that we leave open because I'd like to get some feedback from the practitioners.
Okay. Okay. Anybody else? Well, with respect to subpoenas, okay. So we can move on to the next one, which is failure to appear. So this one has at various times throughout the hearing, parties can fail to appear. So if it happens during the portion where it's before oath, I'm sorry. I saw this. Oh, oath just requires the parties and attorneys to be present at the commencement of the trial. If not, then there's a failure to appear. The Loft Board rules, we set time frames and different criteria for vacating a default. So a default happens when you fail to appear. There's a default judgment against the party. So the Loft Board rules allows parties to vacate that default judgment, and it's specified in our rules. Oath pretty much just says, let me read this part again. Yeah, that the party should be there. and that absent good cause, the oath judge will proceed without the party that's absent. Law board rules allow.
Can you?
Oh,
Sorry,
go ahead.
finish.
No, go ahead.
I was going to say I'm getting a little bit lost with the breaks.
Oh, okay, I got what you're saying. I'm gonna summarize it really quickly for you guys. Okay, so if the parties fail to appear, the ALJ can grant relief, which means that when the parties fail to appear, there's a default judgment against the party, which means the hearing can move forward without that particular party's input. They can't present their case because they've defaulted. In order to vacate that default under oaths rules, it's in the discretion of the ALJ to vacate that default. The Loft Board rules has a specific process to vacate that default, and it includes time limits and a standard of care as well. And that's the difference between vacating default with oath and the Loft Board rules. Basically, the ALJ has a discretion when it's before oath, and if it's not before oath, there are time limits that parties have to submit a request to vacate the judgment. I'm not sure if that's a little bit clearer, but that's the gist of what's happening here. The differences between the two.
So, Mr. Clark, so you're saying at oath there's no?
I'm sorry, I couldn't hear you, Chairperson.
Are you saying at oath? Are you saying at oath that there's no time limit to vacate the default?
That's correct. And that's what I read. You agree, Mr. Argoff?
So just to jump in, so the oath rules, they sort of say that a motion must be filed as promptly as possible, but it doesn't specify a particular time frame. So I don't know how open-ended it actually is in practice, but their rules are a bit ambiguous. It's just they have to be as promptly as possible. But it doesn't give a certain amount of days as our rules do.
I imagine they would have up until the close of record before the R&R is issued to do something. But that being said, it's now 4:15, and I do imagine this is something that Mr. Delaney wants to take up with the practitioners, which I would find valuable myself. So why don't we say 1-45 will also be taken up later?
Thank you. So at this point, Mr. Clark, I'm going to ask that we cease discussion on rules, right? So it doesn't make any sense picking up another point here. So we're going to table 140. Is it 143?
It was 1-46. Sorry, 145. You're correct. Yes.
145.
Thank you. All right.
Mr. Chairman, before we conclude, I would just like once again to thank Glenn and Stephen for their work on this, plowing through this and comparing these. Particularly if you've got a baby that keeps you up at night, it's got to be a tall order. So I asked you to do it.
That's what he does at night while he's.
I asked you to do it, and I'm really very appreciative. You guys did a great job with this.
Yeah, this is amazing. It's really quite easy to follow. I mean, the language is technical, but the structure is really brilliant.
Okay.
I also thank you for asking them to do it because it's important. clearly there's a lot of issues that may be minor, but they seem like they add up to something that should be discussed as long as we're doing rules. So, thank you, Chuck.
Thank you.
Okay, I appreciate it. Thank you. And again, I'd say to staff, they've been, they're doing this in addition to participation, and so it's been an added burden on them. So to the extent that anyone here on the board, and Christian, you're a welcome attorney addition to the board. If there's anything that pops out between board meetings, you can reach out to Ms. Lynn, to Stefan and Glenn at the time. I guess go through Ms. Lynn in terms of sharing or bringing some pointing out some stuff so that we can speed up the board meeting time discussion at the board level. All right. So I thank you very much. I am going to close your update. Without objection, I'm going to close the meeting. So this concludes our January 21st, 2021 Loft Board meeting. Our next public meeting will be held on Thursday, February 18th, 2021 at 2 p.m. The governor's suspension of in-person meeting requirements for open meeting law is in effect until January 29th, 2021. So at this point, we do not know whether the next board meeting will be in person or via teleconference. But if you're playing the lotto, I would bet on another suspension. Board members, we will update you as soon as we know the format of our next meeting. We'll also put that information on the Loft Board listserv and post the information on the website of the Loft Board. Board members, please sign and email in your attendance sheets as soon as possible. Thank you and have a great month of January. Thank you.
Thank you. Good night.
Good night, everyone.